Hello everyone, welcome to the DPIIT-IPRCHAIR IIT Roorkee YouTube channel. Today we will understand a major turning point in India's patent law history with the case of Novartis AG versus Union of India and others 2013 and which is decided by Honorable Supreme Court on 1st April 2013. So the slide is showing all the details of a case with citation, date of judgment, and the judge's bench, as well as the important section which were involved in this, like Indian Patent Act 1970, Section 3D, 21J, 133, 24A, and Constitution of India's Article 136. With this landmark judgment interpreted Section 3D of Indian Patent Act 1970 and dealt with the important concept of evergreening and therapeutic efficacy in pharmaceutical patents. Background of the case is in 1992, one of the famous pharmaceutical company Novartis patented imatinib internationally. Then in 1998, Novartis AG filed an application as per the TRIPS agreement before the Chennai Indian Patent Office for the grant of patent for an anti-cancer drug that is Gleevec, which is used to treat chronic myeloid leukemia CML and GIST gastrointestinal stromal tumors invented from beta crystalline form of imatinib mesylate. This drug is famously used in the treatment of cancer and the same is patented in more than 35 countries. When Novartis filed its patent application, the grant used to be restricted to methods or processes and not for products in India, as defined under Section 5 of the Indian Patent Act 1970. After the Patent Amendment Act 2005, Section 5 was repealed and patents came to be granted for methods or processes but also for the products. In 2005, patent application of Novartis for the drug Gleevec was taken into consideration and the same was rejected by Madras Patent Office on the grounds that the drug was anticipated by prior publication and failed to satisfy the requirements of novelty, non-obviousness, further stating the alleged invention as unpatentable under the provision of Section 3D of Patent Act 1970. As the said drug did not exhibit any major changes in therapeutic efficacy over its pre-existing form. With this, after that, Novartis filed two writ petition in Madras High Court in 2006 under Article 226 of the Constitution of India. The appeal subsequently stated that the Section 3D of the Patent Act 1970 is unconstitutional because it is not in compliance with the TRIPS agreement and also violates Article 14 of the Constitution of India. Madras High Court transferred the case to IPAB, that is Intellectual Property Appellate Tribunal Board, in 2007. This appeal was finally heard and dismissed by IPAB, stating that the invention satisfied the test of novelty and non-obviousness, but the patentability of the product was hid by Section 3D of the Patent Act 1970. The judgment given by IPAB is to prevent evergreening of already patented product by introducing minor changes and to provide easy access to the citizens of India to life-saving drugs. After that, Novartis filed SLP, that is Special Leave Petition, in 2009 before the Supreme Court of India against the order passed by IPAB under Article 136 of the Constitution of India. Here are the issues before the courts. Is the beta crystalline form of imatinib mesylate a patentable invention? Second, what does efficacy mean in the context of pharmaceutical drugs? Third was whether the increase in bioavailability qualifies as an increase in therapeutic efficacy according to Section 3D of the Patent Act 1970. So, arguments by Novartis, that is appellant, were: Novartis argued that the term enhancement of efficacy and significant enhancement in Section 3D are unclear, making the law vague and arbitrary. Second, they claim their invention was not just a discovery but a patentable invention under Section 21J, fulfilling novelty, inventive step, and industrial use. Then Novartis pointed out that even though IPAB admitted the beta crystalline form was novel, it still rejected the patent under Section 3D, which was unfair. Also, Novartis disagreed with the definition of efficacy as only therapeutic efficacy, arguing that this form had therapeutic effects that earlier forms did not have. Then Novartis claimed that improved bioavailability and stability showed enhanced efficacy. Then they argued that since the original substance's efficacy was never established, comparing it with the new forms of efficacy was incorrect. So, after that, argument by respondents were that the beta crystalline form was not considered novel or inventive due to earlier scientific publication about imatinib. Then they argued that under Section 3D, only improvements in therapeutic effect matter, not just physical or chemical change. They also emphasized that granting patents for minor changes would make life-saving drugs costly, quoting global declarations and public concern about access to medicines. Then the court's observation and the judgment was in April 2013, the two judges bench of Supreme Court of India rejected the appeal filed by Novartis and upheld that the beta crystalline form of imatinib mesylate is a new form of known substance, that is imatinib mesylate, wherein the efficacy was well known. Supreme Court made it crystal clear that in the case of medicine, efficacy in Section 3D only means therapeutic efficacy and states that all properties of drugs are not relevant. The properties which directly relate to efficacy in case of medicine is its therapeutic efficacy. Then in issue third, Supreme Court ruled that about 30% increase in bioavailability qualifies as increase in therapeutic efficacy under Section 3D of Patent Act 1970 if evidence is provided for the same. Then Supreme Court compared the efficacy of beta crystalline form of imatinib mesylate with imatinib mesylate with reference to its flow properties, better thermodynamic stability, and lower hygroscopicity, and held that none of these properties contribute to increase in therapeutic efficacy according to Section 3D of the Patent Act 1970. And Novartis not provided any documents that shows that efficacy of beta crystalline form of imatinib mesylate is more as compared to the efficacy of imatinib mesylate. Then Supreme Court made it clear that India is a developing country and medicine should be available at an affordable price to safeguard the lives of the people, and it will protect the interest of billions of people. So a reasonable and liberal approach must be followed to grant patents. By with this, the court finally held the beta crystalline form of imatinib mesylate is not a new form of known substance and dismissed the appeal by Novartis AG. So here are the references for more information, and thank you so much for watching and stay tuned with us for more landmark judgments. Thank you.